because I'm seeing polls that are phenomenal. But the main thing I got to ask you, look, we got to get out and vote because, bad things happen when you sit back.
The former president continues to enjoy a wide lead in the polls. This is SRN News.
WTVN Pinellas Park, WLCC Brandon.
Faith Talk Tampa, online at letstalkfaith.com. Download the Faith Talk Tampa app.
There's a new poll out on Christians and Israel.
It comes from Lifeway Research, and it finds that only 27% of self-identified believers look to the Bible when they try to formulate their opinions about the Jewish state. Most poll respondents, 56%, say news reports from the mainstream media are the primary influence on their thoughts and beliefs about Israel. Other influences include the opinions of family and friends and interactions with Jewish people. Michael Harrington, SRN News.
One powerful pro-abortion group is changing its name, but nothing else. Officials with NARAL, Pro-Choice America, say their organization will now be called Reproductive Freedom for All. They're also vowing to spend big money in the 2024 election cycle to try to put abortion supporters in office all around the country. Measures on abortion expected on voters' ballots in 2024 in several states. This is SRN News. Winter brings more than just the holidays. As Ed Donahue reports, local pharmacies are seeing an uptick in cold and virus cases moving into the new year, one unfortunate trend popping up all across the country.
Data from the CDC shows between Christmas and New Year's, 38 states had high or very high levels for respiratory illness, fever, cough, and other symptoms. That's up from 31 states the previous week. It covers not just flu, but coronavirus and RSV too. But flu cases appear to be increasing most dramatically. CDC's Alicia Budd says so far this is a moderate flu season, but cases are expected to remain elevated. The agency reports 6,500 deaths so far from the flu this season. 27 children have died. Coronavirus illnesses may not be escalating as quickly as flu this winter, but it is putting more people in the hospital than flu. I'm Ed Donahue.
You'll find more on these stories at srnnews.com.
The following program is sponsored by the law offices of Patrick L. Smith. This is the Attorney Patrick Smith Show. Get ready with your legal questions and call Patrick now. 877-943-9673. Again, that's 877-943-9673. The law office is open. And now your host, Patrick Smith.
Good morning and welcome to another edition of the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith, and we're live today, Saturday, January 6th, and we'll be with you for the next hour. 877-943-9673. That's your live and local studio line to be part of today's show, or email me, patrick@attorneypatricksmith.com. You can always email your questions 24/7, and I'll be happy to get you a response as quickly as I can. You can also talk to us live every Saturday morning, 877-943-9673. It seems like I say it every week towards the end of the show usually, and I am really just blown away by how many of you listen so faithfully to the show. And throughout the week here at the studio, they get tons of calls requesting the office line, and all of you and all of your support and all you do to spread the show's popularity with your friends. Thank you from the bottom of my heart. It really means, and it touches me in a very special way that so many of you love, listen, and support the show. So thank you. And I have no lack of gratitude for everything that you, the listeners of the show, do to support us. So we'd love to talk to you today. 877-943-9673, 877-943-9673. That's your live and local number. For those of you who are new to the show, welcome. I'm Attorney Patrick Smith, a local Central Florida attorney, Florida born and raised. Went to law school at the University of North Carolina, Chapel Hill. Been in practice here for over 17 years in the Sunshine State, offices throughout the state, and happy to help you every Saturday morning by answering your legal questions. 877-943-9673. Give us a call now. We'll get you right on the air with me, and you can ask your legal question, and everyone can benefit from the answer. 877-943-9673. All right, per usual, my wonderful wife, who's often a muse for show prep and topics for the show, made a wonderful suggestion this week that we cover the Corporate Transparency Act, which has gone into effect as of January 1st, 2024. So here we go with the Corporate Transparency Act. The U.S. Department of Treasury's Financial Crimes Enforcement Network, which is abbreviated FinCEN, this is according to their website, by the way, fincen.gov, for those of you who want to read the actual release, began accepting what we call beneficial ownership information reports, or BOIs. The Bipartisan Corporate Transparency Act was enacted in 2021 to curb illicit finance. It requires many companies doing business in the United States to report information about the individuals who ultimately own or control them. Filing is simple, secure, and free of charge. Companies that are required to comply, reporting companies is the term under the statute, must file their initial reports by the following deadlines. For existing companies, for those of you already in existence, reporting companies created or registered to do business in the United States before January 1st, 2024, must file by January 1st, 2025. And newly created companies or registered companies, reporting companies created under this category to do business in the United States in 2024, have 90 days to file theirs beneficial ownership information, receiving actual or public notice that their company's creation or registration is effective. Beneficial ownership information reporting is not an annual requirement, so it's a one-time thing. A report only needs to be submitted once unless the filer needs to update or correct information, so that's on the filer to update. Generally, reporting companies must provide 4 pieces. Here we go, folks. The critical elements, the 4 pieces of information about each beneficial owner: the name, the date of birth, the address, and the identifying number and issuer from either a non-expired U.S. driver's license, non-expired U.S. passport, non-expired identification document issued by a state, local government, or Indian tribe. If none of those documents exist, a non-expired foreign passport can be used. An image of the document must also be submitted. So the purpose of this, it's really to police tax evasion, money laundering, things of that nature, cybercrime, but really I think the heart and soul of it is terrorism. I think they're really looking at seeing how many potential terrorist cells are operating as legitimate businesses, and this is a great way to sort of go a long way in preventing any future terrorist attack from organized terrorist cells operating within the United States. What are the penalties? Well, if you are not in compliance, it's up $500 a day is the penalty, up to $10,000, and there's possible prison time as well. So you want to make sure you get in compliance with this as quickly as possible. So get with your attorney, your accountant, and make sure that you get everything filed with FinCEN for your beneficial ownership information. All right, there we go. Corporate Transparency Act 101 covered today. If you have a question about that or any other legal question, 877-943-9673. 877-943-9673. I'm Attorney Patrick Smith, and this is the Attorney Patrick Smith Show. Let's go to our very first caller of the day. Let's go to Tom in Sarasota. Tom, welcome to the show.
Good morning.
Hey, Tom, turn your radio down for me if you don't mind.
I will.
Great.
Good morning.
Good morning, Tom. How's the weather in Sarasota today?
It's a little overcast, and it has been raining.
We were getting some heavy winds out in IRB when I left the house this morning. How's the wind down there?
It doesn't look too bad at the moment.
All right. Well, how can we help Tom?
Well, on the radio, I hear a number of ads be very concerned about title theft. Somebody goes in and gets your title information on your house, and they forge your signature saying that you sold it to them, and then they slap some mortgages on there or sell the house, and then you've got a legal schmozzle that you have to deal with. Now,
hold on, let me stop you there. What was that word? Tremazzle?
Tremazzle.
How do you spell tremazzle? This is a new word, and my father taught me, if you hear a word you don't know, write it down, look it up in a dictionary. I've never heard the word tremazzle.
My best guess would be SCHMO. I don't know. You're going to lose me there. I'd have to...
MORZEL? Tremazzle?
No, I think it'd be S. It begins with a C.
I'm not trying to hijack your call, but you've got me very curious about this word. So, all right, SCHMORZEL, Tremazzle. Let's see what comes up in the
no, leave out the R. Leave out the R.
Did you
SCHMO O-L. L. Maybe double L. I'm not sure.
Okay.
I think it's
Schlemazel, a consistently unlucky or accident-prone person, according to dictionary.com.
yes.
Okay.
I guess that would be a close approximation.
All right. So back on the main highway, off from the side tangent. Go ahead with your question, Tom.
So I was thinking, I've phoned up these certain companies that will insure your title, but it's like $100 a month. And if you own more than one or two properties, that gets to be a little pricey. So my thought, and I just want to bounce this idea off you, what if you were to put, say you form an LLC or some other organization, maybe you have Massachusetts Blind Realty Trust, and that Blind Realty Trust or LLC becomes a lender on the properties that you own, so that it becomes another layer of hoops that the title thief would have to go through.
You mean requiring notice to a higher priority lender or higher priority note holder, correct?
Yes, it would be exactly. It would be a first mortgage.
But my whole point to that would be if they can create fraud against the beneficial actual title owner, they can do the same thing to the mortgage lender on the first mortgage. So, I mean, I see your point. It's an added layer of protection. I don't think it hurts, but I don't know if you're aware, there's actually a new requirement on any deed or conveyances now. Now the witness is sort of in response to these fears about deed and property theft. The witnesses now actually must put in their addresses as well. And I think that's
now when you say witness, what do you mean exactly?
So when you sign on a deed, you have a notary and you have two witnesses. Previously, the witnesses had to sign their name and print their names. Now they have to sign, print their name, and put their address.
But if the person is going to forge your signature anyway, why wouldn't you just have specious witnesses?
Well, to your point, they can still break the law. That's odd, but it's an added layer of protection. And my point was, it's a lot like what you're doing. It doesn't completely solve the problem because you're right. They can still commit fraud and create fake addresses. But to your point, it's an added layer of protection. So it's a good idea. And I don't think yours is a terrible idea. I just don't think it's a panacea that's going to solve all the world's problems. Although I would tell you, I don't see deed theft that prevalently. I think it gets hyped up sometimes in a lot of these ads trying to push product, but that's my opinion.
Well, it's certainly pushing product. There's no question. Is there any other way that, going back to the idea of the Blind Realty Trust, they wouldn't, they don't know who the trustee is. That's a beautiful aspect of that. So how would they sign off on it, I suppose?
Well, I mean, that could cut both ways. I mean, if you had a foolish buyer who didn't know who the trustee was, maybe you could pull a fast one on them because of the fact that they don't know if it's the right person signing off or not. But a good buyer is going to say, well, look, on this blind trust, I want to see at least a copy of the deck page or the cert or something letting me know that the person giving me this property has actual right and authority to convey the property. But it's a situation where there's usually in these situations, there's multiple mistakes made at multiple levels to effectuate these sort of frauds.
So most people use an attorney when they're buying a property. So that attorney would certainly want to see a sign off from the Blind Realty Trust.
Well, when you're involving a title company, there's an underwriting attorney, but a lot of times they don't necessarily involve title companies and underwriting attorneys. And I think that's what you're seeing in these situations. But right, when you go through a title company and you have a good underwriting attorney, and there's lots of great ones out there who know how to protect their buyers and their sellers both in this conveyance to make sure that everyone walks away happy. So yeah, you just got to make sure you get with a good title agency. And if you ever need a referral to one, Tom, although it sounds like you're probably pretty well connected, I'm happy to put you in touch with some.
Do you, can you think of any other solution other than buying this rather expensive
Yes, if people would
insurance?
just stop breaking the law, that's the ultimate solution. I mean, Tom, we can do so much with legislation, but then we get to the tipping point of we've made it so difficult to move any sort of property. We begin to act like some of the states up north, where moving property gets taxed so heavily because of the fact that it has to be regulated by the government. And so there's a balancing act here. Like we want to keep it, where we can freely convey property in Florida without taking on a huge economic burden, but at the same time protect our
Yes.
citizens. So I think this is a step in the right direction. It's a measured response requiring the witnesses on the deed of conveyance. I don't think we want to overcorrect on this and make it almost impossible to transfer your property.
My county, one of the counties that I own property in, has a program wherein you can contact them and they will.
Yeah, anytime there's a change in title of public record, they'll let you know about that and send you an email. And it is county by county, so check with your county, and they will let you know if they have such a program, and you can sign up for it. And anytime something gets filed with regard to your property, they will alert you.
Very good. Well, I enjoyed the conversation.
Tom, likewise, enjoy the rest of your Saturday and try to stay dry down there in Sarasota, okay?
I will.
All righty.
And don't forget that word.
Yes, sir. I got it
Bye-bye.
up here on my computer, schlemazel. So I learned a new word today thanks to Tom from Sarasota. Tom, thank you. We appreciate you. Have a great day.
You bet.
All
Bye-bye.
righty. 877-943-9673. I'm Attorney Patrick Smith. This is the Attorney Patrick Smith Show. I know I'm getting the messages. I haven't given out the office line yet. Let me give out the office line for those of you who want to schedule your complimentary consultation. And before I do that, thank you to the African Heritage Group of Royal Highlands who invited me out to speak last week. Wonderful turnout, wonderful group with great Q&A. Thoroughly enjoyed that presentation Thursday evening. So thank you. If you have a club or group that ever needs a speaker, we are available free of charge. The number to call to set up that speaking engagement or to book your complimentary consultation with me in the Claremont location, Clearwater, Sun City Center, or Sarasota offices, which are definitely by far the most popular offices. 877-754-6764. That is the office line to get a hold of us Monday through Friday to schedule your complimentary consultation. 877-754-6764. But to reach us today on the show, 877-943-9673, 877-943-9673. As a follow-up piece, before we go to our next caller in Haines City, a follow-up piece to a question from a caller last week about a new estoppel law. Our promise kept. We did look it up, and there actually is a new estoppel law. And the heart and soul of this was the law basically said a lender or servicer's deadline to respond to an estoppel letter request from a record title owner. These are basically in real estate transactions, or fiduciary or trustee acting on behalf of a record title owner was reduced from 14 days to 10 days. Estoppel letters must be itemized. The principal and interest in any other charges. Basically, this is preparing information for closing so everyone knows the proper balance is owed on any outstanding bills associated with the property. But the deadline for response dropped from 14 days to 10 days. So our follow-up on the new Florida estoppel law that went into effect in 2023. All right, let's go to Janet in Haines City. Janet, welcome to the Attorney Patrick Smith Show. How's Janet today?
The weather is wet out here.
I was about to say, has the teeth of it hit Polk County yet? Like I know here.
Oh, yeah.
Okay. All right.
Yeah.
Well, hunker
Supposed to
down.
rain. Where's here anyway?
How can we help Janet today?
Yeah, I have a trust set up, and I want to put my property in the trust. I went down to change the title, and they wanted the actual trust papers, and they was wanting to read it to make sure that it was correct, which I had a lawyer do. I wasn't too happy with that. Do they really have to read the trust?
Not necessarily. What they're doing, let me ask you a follow-up question, Janet. Is this your primary residence?
Yes.
So it's your homestead property?
Yes.
That's what your property appraiser is trying to make sure of. So if this is a trust and it's going to hold homestead property, it actually has to have special language in it so that we can hold that property. So that's what they're not trying to be nosy. In other words, they don't need to know the trustees, the beneficiaries, those sort of intimacies, but they want to see that there's what we call the requisite present possessory interest language in there, so that the property can be held as your homestead property. Was the property, or the trust rather, created by a Florida attorney? Don't say the name, but was the attorney a Florida attorney?
Yes.
Okay. If go back to that attorney, if you still have an existing relationship with them, and just have them show you the provision relating to your homestead property, and then just show that to the property appraiser. I'd probably show them the first page, the signature pages in that particular page. And if for some reason you can't get a hold of that attorney and you just want someone to point you in that direction, free of charge, Janet, I'll take a look at it with you and make sure you find that provision. Okay.
Okay. But is there any other way to do that? I mean, can I, that page where you can add your car, go to a certain person and all, can we put the homestead on that?
Yeah, that's
And,
Florida.
like,
That's
I wanted
Florida
to-
statute 732-515, the personal property bequest. That won't apply. And just to clarify it for the rest of the listening audience, what Janet's talking about are these separate writing attachments we often give clients,
Right.
where there's a 3-column
Right. Well,
sheet
you
where you
said-
can give away the property, like a heirloom Bible or firearm, things of that nature. That won't work on real property, Janet. So real property is going to need to be deeded into the trust, and then the memorialization of that transfer is on Schedule A of the trust, not the personal property separate writing. That's a fine line distinction there in the estate planning documents.
Or then what happens if I don't put it in the trust?
All right. Well, let's use a little Socratic method. What do you think happens if you don't put it in the trust? Do your best guess.
I would go to my family.
Well, you're not far off, but the short version is if it's not in the trust, it's subject to probate. And if you have a good pour over will, it's going to be probated to the trust to go to the ultimate beneficiaries of the trust. If you don't have a pour over will and you have a separate trust, it's possible it could wind up going through what we call an intestate probate and going to random heirs and never reaching the trust. So, yeah, when was the last time you saw your attorney?
Hey, I'm 73. I don't remember.
All right. Was it more
This
than 3
last
years ago?
fall. This last fall.
All right.
No, it was less than that.
All right.
It was sometime this last year.
Just reach out to your attorney and have them give you some clarification. And like I said, if for some reason you're not able to get a hold of them and you just need someone to point you in that direction, we'll be happy to give you a second opinion on that, Janet. Okay?
Okay, I appreciate that, and you have a blessed day.
You too, Janet. Try to stay dry out there. Yes, ma'am. Bye-bye. All righty, this is the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. 877-943-9673. 877-943-9673. And we started the top of the show with a discussion of the Corporate Transparency Act and the new requirement for beneficial ownership interest, or beneficial ownership information, rather. And basically the short version there, if you're an existing company, you have until January 1st, 2025 to file. New companies, 90 days to file. And the beneficial ownership information, again, name, date of birth, address, and then some sort of identifying information like a passport, driver's license, things of that nature. But make sure you get in compliance, because there are some penalties, including $500 a day penalties, up to $10,000, and possible prison time. So that was the start of the show. And before we move on to our next subject, we've got a bevy of calls here. Let's go to Dave in Venice. Dave, thanks for your patience. How are you today?
Good. How you doing?
Great. How's Venice?
It's wet, cold, and there's a lot of old people everywhere.
You mean senior citizens?
Okay.
All right, Dave, thanks for playing along. How can I help you today?
A buddy of mine and I did a little event a while back, and we rallied some food trucks. We had a promoter. The promoter did a lot of good advertising. We joined the promoter and used the likenesses that we promoted. And my buddy, his name's Ian, he got involved, and he was all over the promotions and got everybody there. And the event made a whole bunch of money. And we didn't have a contract, but we did a handshake deal, and we expected some money in return. And the event made a lot of money, and we didn't get any money.
Have you ever done this before with these guys?
No.
All right. I was hoping you'd have some sort of like history and tradition or prior conduct you could point to.
There's involvement, but in events they had, but not in the purposes of maybe, say, doing the marketing and the promotion, and that for the purposes of creating an event or generating funds.
Yeah, you're probably up a creek on this, but what's the valuable lesson you learned, Dave?
Got to have a contract.
You got it, brother. That's it. Put it in writing. And people say, well, no, I trust these guys. They're good. We'll get along fine. And I say, well, contracts aren't for when everything's going right. Contracts are for when everything goes wrong. And that's why,
I couldn't agree more.
Yeah. So that's why when we draft contracts, I like to have our civil litigation counsel be of assistance, because when it all goes wrong, you want the guy who's going to be bringing the legal action or defending the legal action to have had a hand in drafting that contract so that it's adequately supplied with arrows in the quiver for his defense or attack. So, yeah, Dave, you learned a valuable lesson, and you learned it the hard way.
The big thing, too, I'll say, too, is that there's a lot of fine lines with people being creative in the world and having businesses, but they overlook the details that you're talking about, sir. And I appreciate you bringing that up, and I think your show's great.
Oh, Dave, I appreciate your kind words about the show. Let me ask you this. How much did you lose?
I don't know. They made an extra 90 G's and we didn't get anything from it. And everybody was out, whatever was investment related to food trucks in the day, promotion of the event these days. I'm sure you know what that costs. I mean, they just didn't give us anything back. And to me, it's because we didn't have a contract and we should have. And the handshake thing, it works the day of until the money's made, unfortunately.
Yeah. How much do you think it would have cost you with an attorney to get a contract drafted?
You would answer that better than me, probably.
Well, I'll tell you right now.
What money I'd spend in attorneys, I'll say anywhere from $1,000 to $3,000, maybe.
I think you're right on it. Probably closer to the 1,000 mark. I don't know. $3,000 would be pretty steep for a simple
insurance
contract.
for the day. I'm including insurances and stuff too, but I'd say the whole thing would have cost me about $3,000 maybe, instead of letting them, as they say, handle it, which then it was on their insurance and their stuff, and we didn't get anything, I guess.
Well, Dave, lesson learned, and you're moving forward all the wiser because of it. So, hey.
Hey, that phone screener guy you got's awesome too, by the way. You better give him a raise.
Okay, I'll double what I pay him now. How's that feel, Dave?
I'm scared.
All right, Dave, we appreciate you. Have a great day, okay?
You too. Stay dry.
All right, bye-bye. All right, this is the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. 877-943-9673. 877-943-9673. Give us a call now. We're live and local. And before we go to Lisa in Tampa, I do want to give my plug to Stetson University's Model Senate. Registration will be opening here in just a couple weeks. If you have a high school senior or undergraduate student who is interested in possibly having a career in politics, they can visit Stetson University's website and search for Model Senate to sign up for this year's Model Senate competition. 3-day long competition, prize money available to the Best Senator Award, and that will be this year, March 21st through the 23rd at Stetson University in DeLand. Senators will actually be portrayed by students for 3 days. There will be open floor debate, committee, congressional hearings will be held as well. So, and we're lining up our speakers presently. So if you want to attend more or get more information on that, visit stetson.edu and search Model Senate. So, all right, 877-943-9673 to be part of today's show. Let's go to Lisa in Tampa. Lisa, welcome to the Attorney Patrick Smith Show. How are you today, Lisa?
I'm good. Happy New Year.
Happy New Year, Lisa. What's going on?
I recently sold a vacant residential property, and I wanted to know about capital gains. I know I did sell it under value. So I wanted to know the whole thing about capital gains. I guarantee, I'm sure I don't have to pay that, but how does that work? And also, when you do sell a property, how long do you have to reinvest it before you get taxed on it?
Yeah, so Dwayne Bischoff, the CPA, I would instantly bounce you to on that, because those are income tax questions. And in the world of taxation, there's really 4 major transfer taxes. We have, the income tax, which everyone's aware of because of April 15th. And then we have the gift tax, the generation skipping transfer tax, and of course the estate tax, which, by the way, that number now is $13.6 million, the exemption on that. So it doesn't sound like you had a gain at all. You said you sold it for less than the market value?
Yeah, I know. I'm probably the only one right now in this real estate world that's done that. But
Well,
I
was
need to
it-
get it off my hands?
So there's 2 different analyses here. Less than the market value is not necessarily less than your basis. What was your basis in the property? Did you buy this property, or did you inherit it? Was it gifted to you? How did you come into owning this property?
I used to have my house on it. I raised my kids there, and due to foundation issues, we had to demolish it.
Gotcha.
So it became a vacant lot for a couple of years.
Yeah, just give me a call at the office on Monday, and I'll put you in touch with Dwayne, and he can give you some good tax advice as far as what your best options are there on taking a loss or declaring a gain, or how long you have under a reasonable time frame to reinvest into another property. I presume you're just going to take that money and put it in the new homestead property. Is that correct?
Well, once I could find something affordable.
Well, good luck with that, right?
Right.
Plus, you'd probably be paying cash because interest rates right now. I was talking to a banker this weekend. He said interest rates right now are like 6% for mortgages, 30-year fixed.
Right. I mean, someone said that the rates are supposed to be going
down.
I'm sorry.
Yeah, the rates are going to be coming down a
down
little bit is the prediction. We're not a financial show so much, but yeah, that's what I heard too from those in the know is that they expect rates to go down. So that's not a guarantee by
Right.
anybody listening out there who's basing investments off this. Don't do that. We're not an investment show. But yeah, Lisa, any other questions for me?
No, I believe that is it.
All
Thank
right.
you.
Well, here, do this for me. When you talk to Dwayne, so call me at the office. I'll give out the office line here in a moment. When you call us back after you talk to Dwayne and let us know what his answer is, because I guarantee you there's probably a couple thousand other people with this same question listening right now.
Okay.
All right.
Oh, I do have one more question.
Go.
Okay, so my property has been under contract zillions of times, and it's always fallen through for one reason or another. And the last time it fell through, the company that was representing me, I felt that I should have gotten the escrow back because when it fell through, they said they didn't know it was a sinkhole property. But I'm sorry, they weren't representing me. They were representing the buyer.
Mm-hmm.
But the company that was representing the buyer was my represented company just before that. So they were well aware of everything. And I never held anything back.
What did the contract say?
Yeah, I have to go back and look at it. Like
Yeah.
I said, they've fallen through so many times.
Yeah, Lisa, that
But
I
they
can
were
help
trying
with.
to deny it all.
So if you want to get me a copy of the contract, Lisa, that was just Four Corners Doctrine. We're going to go by the words on the page, sort of going back to our previous call from Dave in Venice. You had a contract, and now we're just going to live
Right.
and die by the terms of that agreement. So we just got to go see what the contract said, whether or not you were entitled to the escrow money. A lot of times that escrow money, it's refundable for a period. A lot of times it's up until the inspection period. And after that, then the money, is sort of locked in. But at the end of the day, it's going to be governed by the terms of the contract. So we just need to take a look at it, get it to me, and we'll give you an answer on it, Lisa.
Okay, sounds good. Thank you.
Yes, ma'am. And don't forget to call us back. Let me know what Dwayne says on that. I'm really curious about that.
I definitely will.
All right. Drive safely out there.
Thank you.
All right. 877-943-9673. This is the Attorney Patrick Smith Show. This is the Attorney Patrick Smith Show. And I'm saying that again because we're a legal show. And I'm saying this sort of as an introduction to our next topic. I'm going to risk doing this, and I hopefully don't regret it. So today is January 6th, and I'm going to risk touching the third rail, and we're going to talk about the Supreme Court of the United States. Now, the subject matter of the Supreme Court of the United States is one former president, Donald J. Trump. Now, this is according to Bloomberg, and why I'm bringing this up, folks. I don't want your opinion on Trump, good, bad, otherwise. We're going to focus here on the Supreme Court and sort of the constitutionality. For those of you who are longtime listeners, go way back when we did the overturning of Roe versus Wade, the leaked opinion, and then the actual opinion. Let's sort of have that energy to these calls. So it's going to be focusing on the constitutionality and whether or not you believe the 14th Amendment is being properly exercised. So your comments, your thoughts, your concerns on that is what I'm looking for, more than, hey, I'm for Trump or I'm against Trump or, whatever your opinion on the candidate is. So don't really focus on that. Let's focus on the law side of this. This is according to Bloomberg. All right. Trump's ballot fight plunges the Supreme Court into the 2024 election. Now, you know this, the Supreme Court likes to stay out of political matters for the most part. There's something called the political question doctrine where they love to sort of sidestep being involved in the political process. The judiciary sort of likes to stay above politics and remain sort of impartial. The U.S. Supreme Court, according to Bloomberg, will chart the nation's political future as it confronts a potentially stark choice over efforts to remove Donald Trump from this year's presidential ballot for trying to overturn his 2020 election loss. The court's options include putting the kibosh on challenges to Trump's candidacy with a ruling that keeps him on the ballot nationwide. Under another scenario, the court rules against the former president and paves the way for a year of unprecedented constitutional turbulence. Either outcome is plausible, as the justices weigh calls from both sides to review a Colorado Supreme Court ruling. And that said, Trump forfeited his right to run by engaging in an insurrection, which, by the way, the anniversary is today, January 6th. The ruling, which said Trump incited the January 6th Capitol riot, was the first ever to invoke the Constitutional's insurrection clause against an ex-president. Let's take a pause from the copy. The 14th Amendment here. So a lot of times you hear pundits sort of say the 14th Amendment, the 14th Amendment. None of them actually take the time to tell you what the 14th Amendment says. So let's go to the primary evidence. And at the risk of putting half the audience to sleep, let's read part of the Constitution. So here is the actual Section 3 of the 14th Amendment regarding the disqualification from holding public office. All right. No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. So the question is whether or not the 14th Amendment is being accurately applied here. Now you heard in the top of the hour news for those of you on some of the stations regarding people now trying to have current President Joe Biden removed from the ballot. So I want to know your thoughts on whether or not this is a politicization of the 14th Amendment and whether or not this use for political gain, or is this the proper use of the 14th Amendment? You kind of sort of have to turn back the clock to the founding fathers on this. You have a thought on it. 877-943-9673. That's your live and local number. Let us know your thoughts on the Supreme Court's question regarding the 14th Amendment. 877-943-9673. Give us a call now and we'll be happy to take your opinions. Bloomberg goes on to say, in an appeal filed late Wednesday, Trump urged the high court to declare that he didn't take part in an insurrection. He and the Colorado Republican Party also say the clause, part of the post-Civil War 14th Amendment, does not apply to presidents and can't be enforced unless Congress acts first. If the court backs Trump on any of those issues, that ends it. And a lot of people think that the court may go that way and sort of just settle it and say he's on the ballot. The court has the potential to rival, this case has the potential to rival Bush v. Gore. A lot of you don't remember that because a lot of you weren't alive for Bush v. Gore. And that hit me when I realized a lot of my interns weren't alive for Bush v. Gore. But that was extremely controversial, that decision, and it coming down to something like 500 votes here in the state of Florida to determine the outcome of that. The divided Supreme Court ruling that sealed the 2000 presidential election for Republican George W. Bush. After a 5-week deadlock over Florida ballot recounts, the high court since then has grown even more conservative, in large part because of Trump's 3 appointees. It's also grown more polarizing amid blockbuster rulings and ethics controversies. And that was sort of the outcome of our Roe versus Wade discussion, was the level of divisiveness in the court is at an all-time high. And remember, the one thing we took away from that Roe versus Wade analysis was the majority taking time not to go and attack a dissenting opinion, but to attack a concurring opinion by Justice Roberts. So you're attacking someone who's agreeing with you overall, just disagreeing with you in the rationale. And that's how divided the court is at this point. So under the Colorado model, a ruling against Trump would open a complicated new chapter in the fight, creating a model for other states interested in banning Trump. Maine's Secretary of State has also declared the former president in courts. Michigan, Minnesota, and Florida are among those that turned away the 14th Amendment challenges, but cases are pending in several states, including Wisconsin, Oregon, and New Hampshire. A Supreme Court decision backing the Colorado exclusion could recharge the effort nationwide, including the swing states, crucial for Trump. The 14th Amendment challenge to Trump explained. Here we go. Trump told the court on Wednesday that the Colorado Supreme Court ruling would likely be used as a template to disenfranchise tens of millions of voters. Trump's absence from some primary ballots wouldn't preclude him from becoming a Republican nominee or even being elected on November 5th. The latter prospect, an election day victory, here's the interesting constitutionality of it all, folks. An election day victory for a candidate the Supreme Court has declared ineligible would create a dizzying chain of unknowns, according to Bloomberg, stating that starting with the situation that would face Congress when it meets January 6, 2025 to count the electoral votes, so when the Electoral College convenes. If you are not eligible to serve in the office, Congress might not count the votes for you. This is according to Derek Muller, University of Notre Dame law professor who specializes in election law. So there's a major question about what happens on January 6th, 2025. So stay tuned for more. Even if Trump were to win a majority of electors when Congress convenes, he would still face questions about his ability to take oath 2 weeks later on Inauguration Day. Congress could override the Supreme Court decision, but doing so would require an unlikely, as we covered just now, 2/3 vote. Under the Constitution's 20th Amendment, if the president-elect shall have failed to qualify, the vice president-elect will serve as acting chief executive. That's a mess, according to Professor Mueller. So stay tuned for more. Let's go back to Tom in Sarasota. Tom, you have an additional thought.
Actually, with regard to this topic, my understanding was with that clause within the 14th that you had to that the president and vice president were not officers. I thought they were not, and accordingly, that provision that was created during the Civil War did not apply to, obviously, the president or the vice president. Is that correct?
That's the president. That's exactly what Bloomberg says President Trump's position is. This provision does not apply to us, so it's not even applicable. Whether anything else is true, this provision is being misapplied. So, Tom, it sounds like you agree with that.
I would. Now, the other provision is that there's been no conviction or not even the suggestion that there was an insurrection pursuant to the president. And without that, and in fact, without getting into specific politics, on 2 occasions, or at least on 1 occasion, he's been absolved of any problem in that regard.
So it sounds to me like you're making a due process argument, Tom. You're saying, look, even if this does apply, which it sounds like you don't think it does, the 14th Amendment, but if it did,
of course,
someone subject to the 14th Amendment disqualification would be entitled to due process regarding their alleged involvement in an insurrection or rebellion against the United States.
Well, due process and obviously conviction. And in the House, he's been absolved of any wrongdoing.
Well, like, what do we know about the preamble for cops? You know, every episode starts with, everyone filmed here is innocent until convicted in a court of law.
Exactly.
Yeah. So I see your point on that. I think that's a fair point that say, hey, while many may be convicted in the court of public opinion, that's not good enough for a constitutional disqualification to run from office. I think that
certainly
argument
not
hold water, Tom.
Yes. Hopefully, the Supreme Court will also agree.
Well, it's going to be interesting to see what they do here, and we'll
9-0.
We'll do a follow up piece on it when they do issue the actual ruling. I have my thoughts on it. I think that number one, I could see them punting under political question doctrine or something. But more.
How do you mean under political question?
Yeah,
doctrine?
and so
Would
when they don't want to make a ruling, they basically just punt it back to the states and say, "This is a political question. You guys figure it out." And we want you guys to sort it out. So when they don't want to make a ruling, that's where they will often run to and claim that it's a political question. So although
it would seem that that they've not, they're prepared to take it on in February, and they have not kicked it back to the lower courts, which is normally what they would do. They throw it back to.
So let me ask you this: what do you think about So now that they've sort of weaponized this, and you heard about what they're doing in Maine and what's going on now, where the response is, well, we're seeking to have President Biden disqualified from the ballot for apparently the southern border issues. I mean, this really isn't, this is politics. This is not the proper use of the 14th Amendment when you couch it as a post-Civil War measure to guard against, an uprising of the country and a division of the country like the Civil War.
No, I totally agree.
Yeah.
Neither apply, but on the other hand, if one party is doing this to one president, the other party, perhaps just to demonstrate to the general public, perhaps they should go ahead and do the same thing regarding all this border not insurrection, but all this border not following
This
the
voter schmozzle, we'll call it.
Incidentally, schmozzle to me meant mess, not it wasn't an individual person. But
I
that's
knew
okay.
what you meant. I knew what you meant. All right, Tom, we appreciate you calling back. Thank you for your insight. Okay.
You bet.
All
Take
right.
care.
877-943-9673. This is the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. And we will be, of course, with you next Saturday. And if you ever have a topic you want to hear discussed on the show, you are welcome to call me at the office. Clients all the time mention, hey, why don't you do this on the show? So we take that under advise, and the good ones we definitely prep and put on the air for you. But you can email me if there's an article you want to discuss. Send me the article. I'm happy to consider it. But constitutional law always gets my attention. It's sort of one of my hobbies. It was definitely my favorite subject in law school, next to wills, trust, and estates, which is what I do every day. So it's a lot of fun to get to sort of dip your toe in the pool of constitutional law. And we look forward to a follow-up piece on this segment once we have a Supreme Court ruling. And we'll stay tuned. Stay tuned. If you want to be part of today's show, 877-943-9673. 877-943-9673. You can always email your question too, by the way. Patrick at attorneypatricksmith.com. Patrick at attorneypatricksmith.com. And again, that office line for those of you who want to reach us at the office during the week, 877-754-6764. Again, that toll-free office line, 877-754-6764. All right, let's go to Bradenton. Let's talk to Julian. Julian, welcome to the Attorney Patrick Smith Show.
Hey, how you doing?
Good, Julian. What's going on?
Well, I was just, in the studies and the logic that I have about the 14th Amendment and what I just heard you read, as far as somebody helping and or guiding somebody to do an insurrection or do an insurrection themselves as well. I don't think that that to me is that important. I mean, it is, but it's not. What's more important to me is the fact that when the Section 3 was put in, I wonder, and I don't know, so I'm asking, were any of the people that this was applicable to, were any of those people found guilty of insurrection? Did they go to court? That I don't know. So I want to be knowledgeable about it and understand. Did they have to go to court and be found guilty of insurrection and or treason or whatever it is?
No, Julian.
Supposed to be doing?
Julian, this is a great point, and it's a great project for the interns. I'm definitely going to kick this to them. What you're talking about is something called precedent. So we need prior cases where parties have been disqualified from running for office under the 14th Amendment. Thank you, Julian, for that. I'm making the note now. We're going to do a follow-up piece on this, probably when we do the actual opinion. Actual cases where parties have been disqualified. And then you're right. We can just compare apples to apples, compare it to President Biden's contact on the southern border and compare it to January 6th and just sort of see how much does it align to previous cases where a candidate was disqualified. What a great litmus test, Julian.
Well, hopefully there's an answer to it. I assume and I also wanted to comment, if I could,
go ahead,
real briefly.
I have about a minute.
Okay. I just wanted to comment real briefly on the Supreme Court taking this. I myself personally, even though it's 6-3, the politics of it doesn't matter to me, and it really shouldn't matter to them either. But I really honestly believe that they won't kick it back down to the states. And the reason why they won't is because there needs to be some. It's not like something like Roe v. Wade that's been around for 50 years and they know all about it. They know nothing about this. They're going to do some major studying on it, and I think there's going to be some some dissents or whatever they do. There's going to be a decision on it from the court, I believe. I think from SCOTUS there's going to be a decision.
Yeah, I'll
so
go ahead
that's
and
just my
call-
opinion.
Yeah, no, Julian, I appreciate you calling in. I'm gonna have to let you go because I got to wrap up the show. But Julian, we appreciate you. Have a great Saturday. Okay. All righty. This is the Attorney Patrick Smith Show. I think Julian's right. I think it's probably like a 6-3 decision, or maybe even a 5-4. I don't think it's going to be a 7-2. But 6-3, 5-4, something like that. So stay tuned, and we'll do a follow-up piece on that. This is the Attorney Patrick Smith Show. I'm Attorney Patrick Smith. Again, that toll-free number to be part of next week's show, 877-943-9673, or to reach me at the office during the week to schedule your complimentary consultation in Claremont, Clearwater, Sun City Center, or Sarasota, 877-754-6764, 877-754-6764. Everybody stay safe. God bless. Have a wonderful weekend.